Hello everyone, a very good evening to one and all present. Welcome to the India Data Protection Summit 2020, this next session. Today on the panel for the discussion on the topic, just a minute. The cross-border transfer is the topic for the day, and on the panel we have Mr. Rajesh Vishwanathan, SP Arya, Meena Lal, and our own Navi sir to anchor the session. Before we start, would like to give a brief introduction of all our panel members. We'll start from Meena Lal. Meena Lal has been, just a sec. Meena Lal is a gold medalist in LLB from Jabalpur University. She started her career in 1988 and practicing advocate in High Court of Madhya Pradesh at its principal bench at Jabalpur. In short span of practice of a year and a half, she was appointed in some cases by High Court, and also, to her credit, few judgments in cases argued by her reported. Later, she joined Tata Steel as in-house legal counsel. In Tata Steel, Meena rose through her levels and has been heading the legal function at Tata Steel since 2008. In her current designation as Chief Legal, Industrial and Litigation, Meena has rich experience in dealing with litigation in diverse fields of law, such as criminal, land mining, environment, forest, labor, to name a few. She has an experience in field of contracts, several kinds of dispute resolution. During recent times, she has been involved in policy making for data protection in her organization and is also a member of board on few Tata Steel companies. She is a keen learner and a passionate professional. She has contributed into the volume 8 of book series written by Mr. Samraditya Pal titled Constitution of India, Its Origin and Evolution. We welcome you, Meena, for today's session. Next, we have...
Thank you, Sanyogita.
Yeah, Meena. Next, we have Mr. SP Arya. SP Arya is a technocrat presently running a CIO advisory and IT consulting company, BizTech Advisors Private Limited. As partner and director technology, he carries a vast experience of more than 35 years and had held IT head and group chief information officer level position in large companies like Surya Roshni, JK Dairy and Foods, Hero Cycles, LPS Group and MTech Group. Besides being group CIO of MTech Group from year 2007 to 2015, he had additional portfolio of COO of their infotech company, TerraSoft Infosystems Private Limited. Additionally, Director of Fence Auto Limited, manufacturing high-quality iron casting manufacturing company. He has been writing actively in various magazines and web blogs and participated in many panel discussions and speaker as well as moderator. He was figured out in top 50 CIOs for 3 consecutive years and awarded in CIO Power List 2015 in 2 categories. He has been General Secretary, Vice President, and President for 3 years of CIOs of India, a forum by CIOs for CIO in Delhi and NCR, and now serving as body mentor. He has been jury member of one of the prestigious award, IT Next 100, since its inception for 5 consecutive years. We welcome you, Mr. SP Arya, for today's session.
Thank you, Sangeeta.
Next, we have our very own Rajesh Vishwanathan, who had been a mentor for all of us at FDPPI and giving us ins and outs about data protection. Mr. Rajesh Kumar is currently in role of Group Manager, Privacy and Data Protection Officer at Infosys Limited. Rajesh is a law graduate by profession and is certified in field of privacy and information security. Awarded Fellowship in Information Privacy by International Association of Privacy Professionals, US. Rajesh Kumar was member of Asia Advisory Board of IAP, the founder of Bangalore Knowledge Net chapter of IAP India, and has long held positions of trust. On public front, Rajesh lectures and conducts seminars, discussion regularly at big forums on big data, Internet of Things, privacy, security, data protection. And he holds lots of certification in field of privacy as CIPP, CIPP Asia, Europe and US, CISM. We welcome you, Rajesh, and wishing you good health and recovery. Thank you, Rajesh, for joining us. Thank you, Navi sir, for holding the session, and over to you for the panel discussion.
Thank you, Navi. And welcome once again, Meenalal, Arya, and Rajesh. Rajesh will be invisible today, but it doesn't matter. He will be there on the voice calls. Okay, fine. So today, our topic of discussion is the very controversial issue of cross-border transfer of personal data. So far, we have had 3 sessions in this particular series. We started with a discussion on PDPA in general, with reference to the data breach incidents which have been there in India for quite some time. And then we went on to discuss the difference between the PDPA and GDPR to some extent, so that we could cover more aspects of PDPA. Then in the morning, we also looked at the professional implications in terms of the career opportunities for DPOs, which will be emerging because of this law. And today we are continuing the discussions on this cross-border transfer, which is one of the most hotly debated topics in this field. Tomorrow we will be discussing data trust score and audit-related issues, and then the framework for compliance, which is the PDPA side. Okay, now as far as India is concerned, we started our data protection legislation draft with the version of 2018, PDPA 2018, which was following the Sri Krishna Committee report. And that had certain provisions. Basically, what it said was, whatever personal data is classified as not sensitive, that is simply personal data, that is individually identifiable personal data, that was freely allowed to be transferred out of India. But whatever was considered sensitive personal information, it said that one copy should be kept in India. They call it as one serving copy to be kept in India, but otherwise it could also be transferred. Okay, that was the PDPA 2018 version. Now, in the current version of 2019, which was the modified version, because the 2018 version lapsed because the parliament actually went into a change. And once the new parliament came, by that time, public comments for the earlier draft was also available. So the government redrafted it. And some of the public comments, particularly from the industry side, were heavily in support of opposition to the concept of what they called as data localization. That is, keeping a copy of the personal data in India was severely opposed by parts of the industry. And for some reason, the people who drafted it, again, they actually omitted that clause also, so that today even the sensitive personal information can be transferred out of India, subject to, of course, certain controls like the consent and other things. Now, there is a particular classification of information called critical personal data, which may be restricted even now. But as of now, no information has been classified in the draft as critical personal data. It is left for the DPA to perhaps come up with a definition of critical personal data. We are presuming that data such as biometrics or DNA or something like that, which are presently identified as sensitive personal information, may be redefined as sensitive personal information. There are other theories that maybe the defense data or something like that, based on that kind of categorization also, certain data may be classified as critical. That is based on the origin or something. We do not know what is the mind of the DPA because DPA is yet to be appointed. But there could be a classification of critical personal data in due course, which will not be transferable. But sensitive personal data can be transferred, which can be done through the consent mechanism, through the mechanism similar to the BCR, that is the intra-group scheme. And so there is virtually, there is no data localization now in the current version. In the meantime, globally, we saw that there were a lot of developments in the EU, and the EU Court of Justice actually disabled the US Privacy Shield, which was a mechanism for free transfer of data between EU and US. And following that situation in the global scenario, as far as whether personal data can be transferred out of EU region or not, has undergone a change. We will discuss that in greater detail with our experts. So we are now in a situation where the Joint Parliamentary Committee is yet to finalize all the aspects of the bill. And this particular section on whether personal data can be allowed to be transferred out of India. If so, whether it should be restricted to the non-sensitive personal data only, and for sensitive personal data, should it be completely barred from transfer except through various controls, or as in the original kind of condition that as long as you can keep a serving copy in India, you can transfer, kind of a thing. I think the JPC may recommend to go back to this 2018 version. We have to wait and see how things will turn out. As we know that yesterday, our IT Minister, Mr. Prasad, did make a statement that they are working at getting this bill passed as quickly as possible. The schedule now is for the February of 2021. So we're happy that at least a statement has been made, so that probably they will keep up to the schedule. But some discussions are still going on in the JPC, and I'm sure this particular clause is the most widely debated. This is the background as far as the cross-border transfer of information is concerned. Now I will go to the experts on the panel to actually elaborate on that. And we will start from the beginning. I will first go to Meena Lal herself. Basically, to just make our audience understand this concept of why there should be restrictions on cross-border transfer of personal data at all in any legislation. Can you just give your thoughts on that?
Okay. Thank you, sir, for giving that wonderful introductory preface. Friends, let me tell you, as I was studying and preparing for the session itself, and let me tell you, I'm a learner, and along with this program, I am learning myself. I came across an article. The purpose of the session and the purpose of the entire summit, for that matter, is talking about privacy. Now, I asked myself a question. Is this a new discussion and debate which is going on? The flow of data to other countries or the right to privacy, is it totally a new discussion? I came across, very interestingly, an article which was written as far back as in 1890. And it was written by two famous jurists, and that article is called, perhaps that's the most influential law journal piece ever published. It was written by Samuel Warren and Louis Brandeis. They actually vented their frustration. What was that article about? They vented their frustration into the intrusions by the journalists of the 19th century. And can you recall, you can immediately relate to it, in the present times, we also are having a debate around that subject. With a firm command of English precedents and masterful logic, these commentators urge the courts to combat this threat to individual privacy by adding a broad new right to the common law, which is called the right to be let alone or the right to privacy. The right to be let alone is what we are talking about when we talk about right to privacy. So, and frankly, the idea of liberty is very, very complex. The idea of three terminologies: liberty, privacy, anonymity. In fact, let me tell you, friends, privacy and anonymity are actually two sides of the same coin. The protection of a right, which can be granted to an extent to keep my data private, and on the other side of the wall, it cannot be determined that it was my data, then that is anonymous. Otherwise, it is not anonymous. So I may have the right to privacy, but whether I have anonymity or not, and why this cross-border data debate is emerging in such a huge complexity, with such huge intensity. The reason is whether that data would remain anonymous, whether it would be masked or not. Of course, Article 12, I need not remind you, everybody is aware of Article 12 of Universal Declaration of Human Rights. In India, let's touch upon the Indian aspect first before we come on to the specific law. In India, the Constitution of India contains an Article 21, which has been very recently, last week, in fact, interpreted by Supreme Court, and we are still awaiting the judgment when they granted bail to the Editor-in-Chief of Republic. So how did they give bail is on the basis of liberty. Now this life and liberty, Article 21, which resides in Article 21, is actually, Article 21 encompasses a huge gamut of liberties, privacy being one. The K.S. Puttaswamy judgment, which has been passed by Supreme Court, is precisely on the basis and foundation of Article 21, that right to privacy is a fundamental right. That's how the Constitution encompasses the right to privacy. Talking very, very specifically about the IT Act. The IT Act also had, originally, you see, the IT Act did not have any provision with regard to protection of data. Later in 2006, an amendment was brought in. In fact, in December 2006, the amendment was introduced. As a matter of fact, it was 16, not 2006, but it was 2016, that the amendment was brought in, and compensation had to be borne by organizations which would fail, which would breach protection of data. Section 43A is a provision which is contained in the IT Act, and also there is a punishment. So there is a punitive action for non-protection of data, that is personal data, as well as there is a civil remedy, which is compensatory remedy under the IT Act. Is that sufficient? I do not know. So far, Section 43A and 72A have not been worked so much. They have not undergone evolutions as much, but they are contained in law, which means the attention of the lawmakers was already drawn to the existing IT Act. Along with amending the IT Act, they even amended the Evidence Act, Criminal Law, IPC, etc., only to enforce and manifest the importance that the protection of data must have. Having said this, it's very important to appreciate the fact that indeed there is an anxiety. There are disadvantages and advantages of having cross-border, free flow cross-border on the subject of data. Now, when we talk of data, we know we are not talking of boundaries. We are not talking of territories, because data is free flowable. Now, these two provisions in the IT Act are quite an indication that it is very, very necessary to protect sensitive personal data, critical information, critical data of the country. Now, critical data of the country, Mr. Navi created a distinction between personal data and non-personal data, but critical information could be non-personal as well, but very, very important for the purpose of protection of national security. Therefore, it's hugely of eminence that these debates go on in the country. I hope JPC is having rich debates to figure out how these provisions should exist in the new law. I also want to mention one thing, that assuming that there would be new provisions in the PDPA, they will have to be reconciled with the IT Act. Either the IT Act provisions will have to be made mild or subdued or done away with, or data protection will have to supplement and further endorse the IT Act law. So that's my view about the necessity of having the provisions in the law for protection of data. People have to be left alone, and therefore it is very, very necessary to protect the data of the people. And today, when we talk of life and living, it's all surrounded by data. We are creating data, we are flooded with data. Therefore, it's very important to protect the privacy of people, and the law has to regulate it very, very appropriately. Thank you, sir.
Okay, thank you. We will discuss there's certain points which you raised regarding the privacy and anonymity, as well as whether ITA 2000 and PDPA supplement each other or something, to the later part of the day. Let us now focus back into the cross-border
yes,
transfer issue only. Okay. Now, one point which you rightly brought out was Section 43A of Information Technology Act, which was followed by the rules which was provided in 2011, did make a mention of restriction on cross-border by making a mention about adequacy countries, that is countries which had adequate protection, and only to those countries it has to be transferred. Of course, Section 43A is entirely based on the contracts between the data processor in India and elsewhere. Now, I would like to call Mr. Rajesh back into the discussion. So the origin of putting a restriction on cross-border transfer started with ITA 2000 for Section 43A. Now, as I told you, the 2018 version had one kind of a restriction, and 2019 version is a little diluted one. Can you just elaborate on how this law of cross-border transfer in India between these three legislations, ITA 2000, PDPB 2018, PDPB 2019, how it evolved from one to the other? Your views, Rajesh.
Thank you, sir. So, see, from the IT Act, IT Rules 2011, Rules 7 spoke about transfer of personal data, which it also kind of created a scenario which was open from the Convention 108 and later followed up on the EU directive. So what happens is, when we talk from a cross-border data transfer, typically it emerges from a law that maintains trade and free flow of information. So because economy is also more important, so organizations needs to thrive. On that basis, cross-border for an economic cause need to be supported, unless or until there are certain specific sectors. Specifically, we talk from telecom or banking, where there are certain restrictions that would require. In those natures, the data needs to be retained locally. Then with the advance of IT, we had cloud computing and other major technologies that came in, which was able to absorb huge space, cost, which can further promote businesses. And that resulted in a lot of organizations coming up, opening up storage and other hosting service providing in a different location that also promotes from trade. So ultimately, any cross-border conversation triggered due to trade. So I would definitely see it in those parallels that it needs to meet the the country's developmental status from an economic standpoint. At the same time, also to create and maintain some kind of a balance on check that the data subjects whose personal data is being available, how it is being functional from a privacy or a data protection rights perspective. So I think that's where it all emanated. So 2011 had a very 40,000 high feet level, but with no clear stipulations in terms of what is the adequacy, to which would be those countries, which sectors. In 2018, I think after EPISHA, Mr. B.N. Krishna's statement report, it was very clearly laid down, and he was able to capture some of the instances from inputs from the GDPR and other major legislations. And he was able to carve it into the sense where he was able to give a kind of a structured phenomena that, okay, these can be certain places where India as an organization can determine adequacy. And these adequacies can be, which is already, like, for example, recently Dubai came out with its law, and it almost adopted that all those countries that EU Commission has identified as adequate is considered to be also adequate for Dubai to be considered. That data can be transferred. Then came in the instances where certain specific instruments can be used. BCR is one of the other mechanisms. So these aspects came into structure, which set out different instruments can be used by organizations in order to promote cross-border data transfer. In 2019, 2018, another issue that crept in was bringing in another concept called data localization. I think that created a little bit of a distinction in the way how cross-border needs to be effectuated. And in those approach, even though Justice Shah, Justice B.N. Krishna took inputs and insights from the Russian methodology, I think there was a little bit of deviation that led to 2019, and finally with RBI coming back separately, having its own model, and I think sector-wise it started splitting in. So I think that's how I found the cross-border data getting entangled with another concept of data localization is actually turning or changing the way how a cross-border is actually interpreted. If you go back in the 1995 EU directive, because what the Convention 108, what the EU directive, what GDPR talks from a cross-border is very different from what cross-border sometimes gets entangled from our Indian PDP. I think there is for me, from my perspective, I see there is a clash in terms of two different concepts combined in the Indian concept, ultimately creating more risk and more interpretations and jargons, which may definitely lay out a lot of ambiguity in the concept.
Okay, thank you, Rajesh. Now, of course, both the advocates have a particular view, and I will again will discuss about this concept of this data localization. Actually, how did this term came up? Was it the Indian lawmakers who used that data localization, or was it the media, or let us say the industry which started using the terminology called data localization? Because PDPA 2018 actually did not talk of data localization. It only said one copy has to be maintained in India. But somehow the media, as we know that many times media actually determines the points, at least for narration. And they started calling the data localization, basically because part of the industry did not want to rejig their current processing systems, at least to maintain a copy in India. What PDPA 2018 said, that it did not say you don't process it outside India, whether it was Visa or any other company which was very much interested in this change. The law did not ask you to stop processing outside India. They said that save a copy in India because, why? What was the need for that? Because the law enforcement had a record of non-cooperation from these data processing companies whenever some information was required for the purpose of some law enforcement requirement. We'll come to this again now post-Schrems, how this affects. Now we'll go to Mr. Arya. I look at Arya as a representative from the industry. Now, while the privacy activists are talking about this restricting the flow of personal data from my country to a country where the system or adequacy is not sufficient, because that is the basic argument. EU does not want the data to go to a country where the system of security for personal information is not good enough. So that is the crux of the problem. Now, from the industry side, how has this affected the data processing industry in India? We are talking of the data importers. So let us look at India as a data importing country, data exporter being in, let us say, EU. And has Indian industry been receiving data for processing now, not only now, 2019, 2018, or 2011 when 88-2000 amendment came, even earlier, if we were having certain data processing happening, how were they happening and what was the issue with the industry? So, Mr. Arya, can you just tell me whether Indian industry really suffered out of this restrictions or how it will suffer in future? What is your thoughts on that?
Hello, hello. Good evening, everyone. Thank you, Navi, for this question thrown upon me. Being from industry side, I think data processing was not a problem. Okay, so far because there were some certain SCCs or BRCs between the two countries and companies, so they were governed by that. And now, since this GDPR or PDPA sort of legislations are coming up, so they are putting more burden, can say, on industry to be careful about processing of personal data, especially. Okay, so now I think it's not only personal data if we talk about, but it is the, can say, accounting, financial, or other data also, which is also being restricted. Okay, since PDPA is restricted to personal data, so we will talk about personal here only. But yes, together with this, the countries, various countries, if you see, are putting their own restriction, and India itself, because of this reason, our data is going out and some data is coming to us. So every country which is sending data across the borders need assurance for their personal data to be secured enough that if another company which to which it has been transferred doesn't transfer it further to a company which is not complied with the legislation. So those kind of can say fear are in mind of the people or industry. They want their data to be protected, and other countries which are sending to India their data, exporting their data to India, also they are also apprehensive of those legislations and want India to be complied with their legislations and have a legislation which conforms to their standard, and their data is not breach, or you can say is vulnerable to breaches, or not given to any third party which doesn't keep it the way they want it to be. So those fears are in mind of the industry actually.
There are actually two aspects here. One is that India is a data importing country where the data exporter needs assurances that the information will be secured while it is in the custody of a data processor here. Data controller sits there, data processor is sitting here, and whether he will secure it or not. Now, there are international accepted best practices for securing the information, including the ISO 27001. Indian companies, large companies have all been followers of ISO 27001. So as far as the personal data which has reached India is concerned, in terms of the general principles of security, the confidentiality, integrity, and availability, I don't see why anybody should have doubt about the Indian companies being able to secure the personal data, because we are using the same systems which are being used by others. But where the problem actually could arise is something which perhaps earlier was not considered important, but now is whether there will be some kind of an infringement from the law enforcement to that particular data. So this is the concern which perhaps EU and others are having. It is not about security. Security is adequate because we are also using the same encryption methods which others are using, same IDS systems or same firewalls. There is absolutely no need for us to think that there is something which is weaker. Of course, earlier we used to say that US was perhaps using a higher level of encryption and it was not exported or something like that. I think those days are gone. Now India must be having as much of security as far as information is concerned as the rest of the world. But the legal aspects will come separately. But as far as the data arising out of India is concerned, then the question of this, what we are referring to as data localization, or they're putting restrictions on Indian data going out of India, is also being looked at from the concept of data sovereignty. There is a demand that data belongs to us because data is valuable. You call it as oil or gold or whatever is that, data has value. and the country is generating data, and we are perhaps in the next 2 years looking at how to monetize this non-personal data. Therefore, the data has to be considered as a valuable asset of the nation, and data sovereignty has to be recognized. Now, when we talk of data sovereignty, we are not only talking of personal data, but non-personal data also.
Yeah.
But personal data becomes important because the profiling of some of the financial transactions which can happen in India, because India is today perhaps globally in the forefront of use of digital payment mechanisms at all levels. Our villagers are using UPI systems. I don't think that is so common in other countries. So profiling of financial transactions actually gives the complete, you can say, idea about how Indians behave. And that profiling data is perhaps considered extremely valuable by international people. And therefore they want Indian data, okay? So they don't want to send the EU data to India because
Yes,
India is not considered as adequate security for whatever reason. As I told you, we are using the same technical measures, so there should have been no problem. In fact, many of the earlier contracts were based on contracts. If your company agrees to secure, they used to send it. Only after this last 1 year, say after Shrems, we are actually going beyond what is apparent in the contract. We are talking of the standard contract clauses to be hardened, and we are even questioning the BCR kind of thing because it was forced on EU Data Protection Board by the court decision. Courts have their own minds, and they felt that the privacy shield is not acceptable, so they forced that. So as far as India is concerned, if data is generated in India, whether it should be allowed free export has to be looked at with a free mind. Say if if EU has got the right to protect the data from the privacy angle, let us say they are only worried about privacy. They are not looking at holding on to the data because of its monetary value. Let us give them the benefit of that. But they feel that the privacy of a EU citizen will get compromised in a country like India, where our Indian companies are not able to secure. That is their concern. Yeah. But at the same time, why Indian companies should freely share their data is the concern which made the Sri Krishna Committee and PDPA 2018 talk of taking one step towards at least making this valuable data being available in India. Okay, still we know that once one copy is given outside, the monetary value has gone outside. Say, for example, today we are talking of India, a country where there are organizations like CIBIL, which has the profiles of a lot of transactions, of financial transactions of all over citizens. And originally, CIBIL came up as a consortium of Indian bankers. So the financial transactions data was shared with them. But now the shareholding of CIBIL is with TransUnion, and therefore TransUnion, a US company, has got control over 500 million sensitive data sets. So data export of sensitive nature has already happened. So there are various ways in which India so far has not exercised any control on cross-border transfer. Now for the first time, because PDPA is coming up, there is a discussion on to what extent we will allow, and if we allow, is it absolute bar? There is no absolute bar. Even in PDPA 2018, there was no bar. So there was no data localization. It was only keep one copy here. There are two purposes there. If you keep one copy here, the law enforcement, if it requires that data, then because we are talking of data generated in India, which is relevant for the law enforcement in India, cyber crimes in India. Therefore, if the law enforcement wants, we didn't want the organizations to put an excuse saying that I cannot give you the information because we value privacy. You go to Google and ask for information, they say we will not give the information. We will hide the information in Gmail by giving proxy IP addresses. Then all domain name owners, registrars are telling we will give proxy name, so that if any phishing website is there, you are not able to get the owner's data except through legal processes. So internationally, this concept of data transfer has come into a debate because the international companies have not been cooperating with the Indian law enforcement situation people. But of course, I am not holding any kind of a support for law enforcement in states like Maharashtra. Okay, there the law enforcement is of a different nature. In fact, I am on record saying that the activities which has happened in Maharashtra is a big advantage to international companies to deny adequacy, at least in the state of Maharashtra. In fact, because the exact point which they raised for US Privacy Shield, whether law enforcement will have a overriding power to ask for information, it was actually proved beyond doubt in the state of Maharashtra that yes, law enforcement people can do whatever they want. Therefore, that has affected our status as adequacy unless the different states start doing it differently. So this data localization, let us look at the Indian context, whether India has got a data sovereignty rights. If so, then we have to be a little lenient on this policy. But right now, anyway, it is not an issue in our PDPA in 2019 because both sensitive data and non-sensitive data is allowed to be freely transferred. What you need is an explicit consent, a BCR kind of an arrangement, and a contractual arrangement which is similar to SCC. You can always have, of course, your data processing contract will have a clause for securing. Now, we will go more into what precautions the data exporter can take. But before that, we will now try to address this Schrems 2 kind of an issue. Of course, Rajesh has discussed this earlier also in our forum. Now, this Schrems 2 started from the Privacy Shield being negated, and earlier to that, whatever arrangement was there. Now, I would like Rajesh to very briefly trace the development up to Schrems 2 of the US and EU relations on cross-border data transfer. Rajesh.
Sure. So in 2000, there was a sunset provision that was agreed between Europe and US in order to promote data transfers from EU to US. This was a sunset provision in addition to what was already available under the EU directive, that is either to meet adequacy or BCR or through a standard contractual process or kind of an instrument. In addition to these three, US had this permission along with two other countries, which is the Switzerland and Canada, a privacy sunset provision that was set, and that was what called as Safe Harbor 1.0. In 2015, due to a case that was filed by Max Schrems before the Ireland DPO, the Safe Harbor 1.0 got invalidated for the reason because the data that he as an individual was providing to Facebook, which had its servers located within Ireland, was also getting transferred to US. So, and the legal basis and the means of processing was not in line with the EU directive provisions. Now GDPR came in. Meanwhile, the EU and US came up with a privacy shield mechanism that allowed for additional ombudsman rights where data subject rights can be protected. So the whole debatable issue is whenever there is a data that has been accessed by some other entity, whether the individual in the law of the land, the rights that is available to him, can he or she exercise the same rights when his or her data is unauthorizedly used in a country outside and where it has been transferred. So that was the whole mechanism that came in, and due to FISA and other legislations that lead to a lot of surveillance in US. In 2020, on July 16th, the Court of Justice for the European Union invalidated Privacy Shield on the ground that it is okay for a third country to use the data for certain permissible means. It should be necessary and proportionate. And which, if it is not necessary and proportionate, in that case, I don't think the data subject is able to have that right extended even the third country. On that ground, I set the privacy shield, which is agreed with US, as invalidated. So this is not a one whole set totally declaring that the third country is not what the EU wants for the data. EU also wants data to go, but it's just that accountability to make sure that the rights extend and the person is able to have his rights protected in the event if he's, because if I don't know somebody is keep on accessing my data and I don't know behind my back, my financial my financials are getting monitored. In that case, my privacy right is getting impacted. And that's something which the CJU ruling came in. And 2 weeks before, on November 10th, the ADPB came up with the guidelines in terms of what could be those supplemental measures that can be put in place. And it's still in a consultation. And certain areas are more debatable, specifically where recommendations of use of encryptions, which like in hosting service providers, like cloud service providers, which is not possible technically, because at some point or the other in the third country, there's a requirement that the data needs to be decrypted for some basis. So it is right now in public consultations, but however, there is a very clear step in terms of where this guidance applies to those countries specifically having surveillance laws. It clearly agrees every country has its surveillance laws. Every country looks at the data. We are good with it as long as within the limit. But however, depending on the nature and depending on the authorities' interference in the way in which the data wants to, if the data subject rights are not protected, there are certain measures that have been put in place that organizations needs to implement or otherwise suspend any further transfer. So this is a kind of a public consultation that has come in. Till November 30th is the time. We are looking into it. And strangely, the same time, we have also seen the European Commission come up with the SEC instrument revision in line with GDPR as well. So it's a very busy week in the past 2-3 weeks on privacy from an European standpoint. So I think more actions are seen from Europe and California with a lot of changes, which is very interesting, and specifically from a cross-border data transfer perspective.
Okay. Now, I would also draw attention of two of our guests who are here who may have something to add to this. Mr. Sudarshan Mandyam is there, and also we have here amongst the participants Mr. Vikram Patil of L&T Infotech Chennai. I will perhaps try to get their views also on this. But essentially, what we are talking of from Schrems 2 is that the EU Court of Justice is unhappy with the destination country's legal situation where, for the purpose of law enforcement or otherwise, there could be a governmental interference on, we are talking of EU person's data, which is being processed. Say the EU has sent me a set of data, I am an Indian company who is processing it, and whether Indian law enforcement will have some kind of a power on that, or if the EU data subject wants to raise some kind of a rights issue with the data importer. Say normally the data importer should be considered as a processor and the data exporter is the controller. So actually the responsibility should be borne by the data exporter in EU and not make the data importer responsible for the privacy protection in EU. In fact, the latest European data board this thing is a better expression, because they are now telling that the data exporter should actually do a due diligence on the destination country's legal situation and come to their own conclusion. In fact, that they should have done earlier itself. Say the data exporter should first of all satisfy himself whether this particular country, whether it is a banana republic country where I cannot believe anything about what the law says, or it's a country of the nature of China or Russia, or a country like India, which is in between democratic and some other this thing. So it should be the responsibility of the data exporter to make that particular, take a call on that. But the standard contract clauses had one infirmity, which was that in the event of a data exporter going out of business for whatever reason, that is, we are talking of the EU company going out of business, then the rights of the data subject are to be exercised over an Indian company or the data importer company. This was the expectation of the standard contract clauses, which to me personally appears to be a little illogical, but anyway, other experts may have their own view. So therefore, this current clarification, which says that due diligence has to be done, is a good system. In fact, the US Privacy Shield, another area where there was dissatisfaction of the EU court is this ombudsman who was responsible for this resolution of disputes between a EU data subject and a US company. That ombudsman was not a judicial kind of an entity. He was somebody who was appointed by the President of the United States. Therefore, he is subject to the influence of the executive and also the law enforcement. This was the argument. Because of that is ombudsman not having an independent status to resist the request from a law enforcement agency kind of a thing, they said US Privacy Shield would not be applicable. Now, if you come to a country like India, leave aside the exceptional situation in the state of Maharashtra, which I referred to earlier, even in other cases, the law enforcement will have rights if there is a reason. That is, a crime is perhaps prima facie evident in the processing of a particular personal data. And our Personal Data Protection Act has enabled the Indian companies to segregate. If you are processing EU data, they say you please segregate it and get that ODC notified. Then we will identify that as a unit which is different from the local data processing company. So if the police have got something to ask you, let them ask about the Indian data center, not the data center which contains the EU data. So India has made provision in the PDPA for segregation of personal information coming in from a foreign country under a contract, and the local data which is generated and processed, which could be the subject matter of law enforcement on a later day, on which EU should have no objection. So we have adopted that kind of a methodology, and over and above that, it is for the EU data exporters to pseudonymize the data if they want before sending it to India. Therefore, don't worry much about what happens in India. So despite these remedies which are available, we are still concerned about the Schrems too. Now I would invite I have made certain comments, okay? I know that my comments are very different from somebody else, including, I'm sure Rajesh holds a slightly different view, but I would like the views of first Sudarshan Mandyam, whether this Schrems 2 can really be implemented honestly by an Indian company. If I am an Indian company and if somebody asks me, sign a standard contract clause saying that you will take over the rights of the data subject and you will not allow CBI to make some inquiries with you or something like that. If they ask, are we in a position to do that as Sudarshan?
I think so, because I audited so many companies way back in the year 2002, 2003. There are a lot of restriction from Data Protection Act that no data could be parked here. Still, the companies in West want to do business. They want low cost. They want high quality work. Somehow they'll find some ways and means to come and do business. They had some technical controls which I got audited through a specialist. Those days, like, the data was not parked here. Those days, it was the beginning of the industry. Now, one is with the present government, which is running for 4 or 5 years. I have seen even in Dubai, about 10 years ago, no Indian would come and talk boldly with the police or as a manager, bank manager. The last 2 or 3 years, some of the Indians who are living abroad also, they become quite bold. I don't know whether it's good or bad, but I think the nature of doing business has changed a lot in the last, say, 2 or 3 years. Maybe because of the influence of the government, saying that Atmanirbhar Bharat, I think that also psychologically makes people, I think the Indian companies will resist more now than what they did about 20 years ago.
Okay.
Definitely will happen.
Yeah.
Moreover, they want high quality work at a low cost.
Yeah.
Western companies, whatever they say in the law and outside and maybe in a public platform, personally when they want to negotiate a business, they will accept many conditions which our companies will put.
Okay.
Let's give an example, not related to data. About 10, 15 years ago, most of the mobile companies did not have any business. Some of the Indian big telecom companies went and bargained, you supply all the mobiles to me today, I'll pay you only after 3 years. They never seen earlier, but it happened. So like that, our companies may be able to bargain better in future. Psychologically, they're prepared, and then it's also technical controls are very good nowadays compared to what it was about 20 years ago.
Yeah.
I don't think we should judge it only by the clauses or articles of the act. We should look at overall business environment, and this should be one part of that. We should have a holistic view when you come to some conclusion. I strongly believe Indian companies will try to bargain better terms.
Okay. I think Mr. Vikram Patil has some very strong views on this subject also. He has done some extensive research on this impact of this SEMS2. So very briefly, Vikram, can you just give your thoughts on the current scenario as far as data transfer from EU to us? Okay, that is what we are discussing in SEMS. Then whether that can later on be a guidance for what JPC has to do, that we'll discuss separately. Yeah. You are on mute.
Yeah. Yes. Yeah, thanks, Nayu sir. Yeah, I've been listening to all the fraternity on this matter. So actually, this credits to the impact it has on India more than US. Okay, but having said that, we actually do not transfer and store any data locally in India. The data is there in Europe only, and we are remotely accessing their cloud service provider in Europe or outside of the India, and we are doing the data processing from India remotely. Now, even when we do the processing activities from India, the data is actually transferred and shown on your CPU, on monitor, or the desktop. So that means the data has been transferred. You are not storing, but stuff. So in that case, the data, when it is transferred electronically, so what the confusion between the EU Council and the EDPB is that the EU Council says that they want to go with a risk-based approach. When you say risk-based approach, meaning whether the government, the foreign government, the third country where data is getting processed, whether that country government authorities will have access to the EU resident personal data. That risk-based approach they want to go with, and also they have a standard contractual clauses that EU Council has come up with. When we talk about the EDPB, they have a transfer mechanism as per the Article 46, talking about having a certification like Privacy Shield, or you have a BCR, binding corporate rules, or adequacy decision made by the EU Council members for the countries like Israel, Japan, and Canada. They have done Likewise, may probably if India in future may have adequacy decision made for India once we have a PDPA, that will be a strong grounds for data transfer and processing. That will be one. I think having adequacy decision for India would be beneficial. However, before we get into that adequacy decision for India, what another aspect of the CJEU decision says that the India must have a strong judicial redress to address the data subject rights of the European residents whose data is being processed in India. So at this point of time, I'm not clear whether the Indian judicial system has a strong redressal system to file a lawsuit for GDPR data coming from Europe.
Okay. See, of course, the Information Technology Act under Section 43A actually made the liabilities based on contracts. So the data processing contract by a GDPR exporter with the Indian importer was part of the requirements of Section 43A as a reasonable security practice requirement, which under Section 43A, one could go to the Indian court. So as of now, Section 43A provided for what you are just saying, that a foreign company can go to an Indian court based on Section 43A, stating that we had a contract where I had given you certain security procedures, which are to be considered as reasonable security practice under Section 43A. First point in 43A is if there is a contract, that becomes reasonable security practice. If that is not there, we go to the secondary aspects of a law or a ISO 27001 or government notification. So there was a provision now, but Section 43A is now going to be removed after the PDPA comes. So this contract-based support of the Indian legislative system may vanish in the post-PDPA. So whatever protection has to be given, it has to come under PDPA. That is where I feel the Section 37 enabling an Indian processing company to declare that I have got a separate hybrid entity which processes only EU data. If you are a police, don't touch me there. It's in a separate building, separate people are working, and that is a separate, what do you say? It is like your STPI kind of this thing. Don't go there. If you want anything, you please come to my other premises where there is Indian data. We will discuss what rights you have got under CRPC. So this provision has been given under the PDPA. If it is properly expressed to the satisfaction of the EU Data Protection Board by the DPA, then we can claim that there is no concern as far as adequacy is concerned. I am giving you a sort of an offshore data center for EU person. We will process it there. And as far as the technical security measures are concerned, we are using the same technical tools which everybody else is using. And I am not allowing the local police to get into this because we will tell him this is actually an offshore center kind of a thing. So there is a possibility. Of course, I don't give guarantee to police exceeding their authority. See, what has happened in Maharashtra is an indication that there may be something in law, but police may exceed that. That is something which on paper we can do nothing. That is for the governments to decide. Now, because that is why I said it's a legal situation. That's why I would like to draw the attention of Meena Lal in another aspect. See, sometime back, the Indian Supreme Court had to consider the rights regarding a defamation case of Baba Ramdev defamation case, where there was a dispute which was similar to the Google CNIL kind of a dispute. That is, whether there is jurisdiction for Indian courts to look at a data which is lying on the cloud or whatever you call it. If so, on what basis? And the court actually came to the conclusion saying that if data is uploaded from India, I have got a jurisdiction. So that way, now when the Indian data is being processed, which is the subject matter of PDPA. See, PDPA applies to data processed in India, basically. So if it is processed in India and uploaded, Indian courts will have a jurisdiction, Indian law enforcement will have a jurisdiction. But if it is uploaded from elsewhere, it is going to be different. So whether this Baba Ramdev case, though it appears to be a defamation case, not connected with the privacy. See, privacy and freedom of expression, they actually are two aspects of the same this thing. So if a court takes a view on freedom of expression is paramount, police cannot interfere, that becomes a support for privacy also in a way. So can you briefly tell me, Minalal, whether this case is of relevance to justify that Indian judiciary is actually upholding the data, at least freedom of expression in a particular manner. They have defined a manner of recognizing the jurisdiction, which should also be a guidance of for deciding on how the privacy activists should look at restrictions on the access of law enforcement on the data. That is the point which we are discussing. Yeah.
Sir, to talk about defamation and the context that you gave about Baba Ramdev defamation case, the jurisprudence in India and the law in India is that wherever there is the place of occurrence is where the defamation has occurred, that court will have the jurisdiction. Now, if defamation has been caused by an entity which is overseas, but the defamation occurs in India also because of the fact that I have come across an article which defames somebody, that will, it's by itself, because the defamation has landed in India, that gives jurisdiction to the courts. The way Indian law is, CRPC and IPC, the jurisdiction definitely is there with Indian courts, even though the commission of the offense would have originated cross-border. But the fact that the information has come to India and somebody sitting in India has read up that information, that causes the defamation. And most certainly Indian courts will have the jurisdiction as per the existing law.
The problem is, of course, when we say that data uploaded from India, Indian court has a jurisdiction, then Indian law enforcement also will have a jurisdiction. Okay, so that is why it is absolutely essential for the industry to make use of Section 37 of the new PDP Act in such a manner that you create a firewall around this ODC and say that this contains my international personal data being processed under a contract, and it all involves the rights of the citizens of that country. It is not the rights of citizens of this of India. Therefore, the Indian lawmakers have agreed that let it be separate. I don't want to interfere with this. I am only required to protect the privacy rights of Indian citizens. I am not required to protect the privacy rights of the EU citizens. Therefore, don't mix it up and make my work complicated. Separate it. That is what the law has said. But maybe in the procedures and codes and practices related to Section 37, we need to develop certain foolproof documentation of how Section 37 declaration of a unit as a offshore data processing unit is perhaps actioned in India. Rajesh, you have any thoughts on that?
Sorry, sir.
Section 37, how it has to be put into action through codes and practices by the DPA is the point.
Okay, so when specifically we are talking about where Indian entities as a data processors processing data of belonging to residents outside of India, I think I would recommend a process that was adopted by the Singapore Data Protection Act in 2012. I think that would be the best model to start with, where they have the rights, their necessity in terms of making sure that appropriate technical measures and retentions, because I think retention is one of the another principles in a privacy that also will clearly justify, because the more the data you retain, the more the data that gets misused or used in a way which is not necessary for the incidental to the purpose for which it has been collected. So I think for me, at least an approach that way could heat and solve some of the problems. Second, the mechanism that was put in Privacy Shield, I think that's also one thing that which we need to have, because we have been significantly discussing from the fact that in the event if there are things where a data subject rights have been aggrieved, you can't expect a data exporter to file, because the data exporter's obligation to repudiate or fight against the data processor in India is limited only to the contractual perspective alone. But what we are talking from a privacy standpoint is the human rights, the privacy. I mean, if you go and refer back to the UN charters and the European charters, you're talking more from a data subject's rights perspective, which is very different from a contractually argumented statement. So I think that kind of duress rights that can be afforded as a mechanism, and that's where I preferably look at a kind of alternate dispute resolutions mechanisms to be in place, which can allow for such where certain agencies, certain entities takes forwards those requests, addresses the matter, probably resolve issue, because at the end of the day, they don't want to hear no. All they wanted to see is, yes, this was accessed, this is the purpose for which. That's something which that information flow is what is something that is expected. So I think these two things can be taken care within the context of Section 37 of the PDPB in terms of appropriate guidances. I think we'll be able to resolve most of the clashes that we may see from an international data processing perspective. This is my personal thoughts. Happy to hear other comments as well.
Okay. Now, from the audience, are there any specific questions which we can ask our panel to respond? See, we have so far what we have discussed is this cross-border transfer is restricted in various laws. As far as Indian law, latest PDPB 2018, if we restrict to that, the restriction is only for critical data, which will not be permitted to be transferred. As far as sensitive data is concerned, it can be transferred through various mechanisms like explicit consent, as well as the BCR kind of an arrangement, which means that even an SEC should also be possible. So there is really no issue as far as the industry is concerned. As far as the outward transfer of data is concerned, the only issue is if the JPC reverts to the PDPA 2018 version, then the question of keeping a copy in India will come, which is a question of data storage issue. But we are talking of the Indian data. So unlike the discussions we had about an Indian data processor and a EU data exporter, where without retaining the data, he is only accessing it. Say even remote access is processing, but the risk is much less, because after the processing is over, the data is not residing in India. To that extent, risk has been mitigated. So that is fine. Now, as far as Section 34 of Indian PDP Bill 2019 is concerned, the sensitive personal data can also be transferred. This is what we recorded as far as the Indian law is concerned. Now, on the other hand, we also discussed that when we look at the Indian industry trying to process the data coming from outside, we were so far dependent on the most of our business actually comes from US. US companies strike the deal with the EU companies, and then they appoint Indian sub-processors, kind of a thing. So we were dealing with the normal contracts, many times MSA, beyond which nothing else was there also. Many companies were working on that. But the essential feature was that Indian companies were capable of technically securing the data with access control, encryption, and that kind of technical measures. But Indian companies were not so far asked whether your law enforcement can probe into my data or something like that. But that issue has come to the fore because of the Schrems 2. And if that question is asked, I will not be able to give a convincing answer to any EU data exporter that I will be able to resist any police inspector with the rights of investigating a case to walk into my office and demand, for example, seizure of my data center. Okay, because we know what happens if you resist it, kind of a thing. So it is difficult for Indian companies to say that whatever is expected out of the Schrems 2 is unlikely to be supported by the Indian system. And even if a due diligence report has to be given on the request of a data exporter, if somebody does an analysis of Indian laws providing for access beyond the Section 69 of Information Technology Act, which has got its own right to intercept data, provided there is a due process for that. That is a ministry official, secretary of the Ministry of Finance has to give order, etc. But again, that will be again not satisfactory for EU, because in the US case, the ombudsman being appointed by the president has been considered as a person who is subservient to the president. He is not a judicial authority. So what perhaps EU CJ wants is the ombudsman should be a retired Supreme Court judge kind of a thing. So in India, unless we have a system where the DPA, you see, DPA has got this adjudicator who is an official. He will not come into the fit into the this privacy shield kind of a requirement. But there is an appellate tribunal which is envisaged under PDPA. That appellate tribunal will be supervised by a retired Supreme Court judge, perhaps. So maybe by holding out this authority, which will be the adjudicating authority before any rights and other things are to be discussed, India may say that we have something in place. We are not dependent on the adjudicator, but we have the appellate tribunal judicially managed. So these are things which we need to discuss now, whether by holding out this appellate tribunal kind of a situation and the Section 37 segregation, two key points which are there in PDPA, whether India will be able to satisfy the European concerns that Indian data importer will in certain circumstances be able to slightly ward off unwanted interference, in the sense that if a law enforcement person sends a notice, then perhaps there should be an immediate injunction which should be sought from the appropriate court. Then that is the only thing which will be satisfying the European this thing. But right now that sort of an immediate injunction is not feasible. Presently, the complaint has to go to the adjudicator, and after the adjudicator's decision, appeal has to go to the next authority. But still, there is a possibility that if we designed the rules and regulations for Section 37, coupled with this reference to the appellate tribunal in a proper manner, perhaps we may be able to meet Schrems 2 somewhere more than half the way, is what I think possible. And we can have the last word of confirmation or counterpoints from our panel members.
So just to
What
add
I just said. Okay, Mr. Arya, do you have a viewpoint on this? No, you're on mute.
You're on mute, sir.
Basically, whether we can re-engineer the PDPA as of now to meet the standards of EU CJ is what I am trying to think.
Yes. I think present with this case coming into Schrems 2 coming into picture, I think most of the contracts and whatever arrangements are being done between the companies, the data exporters and the data importers, they need to be revisited. Okay, till our PDPA comes into force. Okay, and since PDPA is specifically for data privacy, personal privacy, I think it will address most of the issues which actually GDPR or EU wants. So I think everything have to be revisited at present, and I think a process has to be refined, law has to be taken into consideration, limits and exceptions of both the sides have to be redefined again, okay, till our PDPA comes into force. And that will definitely, can say make a thing workable. As of now, But yes, PDPA once comes into force, it will be a very helpful to the Indian industry, can say for data transfer and data exporting.
Thank you. Rajesh, can you add anything to the discussion?
Just wanted to add an input based on, so there are a lot of Bitcoin events that happens, and some of the major discussion happens due to this CREMS thing. In their analysis against three major countries, that is US, China, and India. India is not at all in a threat list. It's mostly US because of its major surveillance regime, and China because of its dictator internal ruling, firewall ruling. These are the only two countries which they see primarily, which may have an impact from a SCREMS. So that's one good news. But positively, the other aspect of it, if India needs to go to a table, discuss and have a MLAT or some kind of an understanding, including adequacy, the primal issue of addressing both the complement areas of Section 37 that you mentioned, specifically about extending the protection of the rights of the data subjects. I think that's going to be very crucial, and I'm sure the JPC and all the respected experts who are discussing this particular cross-border as a kind of an enigma should look into that as a major key topic from my end.
Thank you. And Sudarshan, you have any views on this? No, mute. You are on mute.
And I'm mainly from the process background. I don't have a legal background. I'll not be able to comment on that.
Yeah. So we'll go to the legal expert here.
So, whatever the law would say, whichever way the exemptions will be granted by Government of India, which I'm sure will be codified very soon once PDPA becomes a law and Section 37 is really being enforced, there will be parameters on the basis of which the exemptions would be granted. But what I wish to suggest is that what would inspire confidence for the purpose of free flow of data, if India is data importer, that situation will be only when we have a very fast adjudicatory mechanism. Now, you did mention about the Appellate Tribunal. The TDSAT today takes care of the telecom disputes. It also takes care of the disputes under the IT Act. And there used to be a Cyber Appellate Tribunal, which has been done away with, and it has been merged with TDSAT. So India has to create a mechanism of a fast adjudicatory process, be it at the initial stage, at the stage of injunction or restraint, or at the appeal stage, or even at the stage of judiciary. It has to be really fast. That only will inspire confidence either in data exporters or importers. That's my suggestion.
Whether it is done in the rest of the country or not, I am discussing with the Karnataka government that we should do it in Karnataka. Therefore, Karnataka will become the focal point, which I have been telling as one of the objectives. Karnataka should become the center of data protection, which also yesterday Ravi Shankar Prasad said to the Chief Minister that you should create a data economy around it. Okay, so I'm already in discussion with the local authorities, because you know that I keep on suggesting things, whether suggestions are taken or not. We have to keep suggesting, so some suggestions are there. Hopefully something is done. And before we wind up, Mr. Kamal Acharya, I would like you to come in and perhaps give some of your thoughts. Kamal Acharya is from our, he's an FTPPA member from UK with a lot of experience in the GDPR area. We are discussing about this SHREMS 2 and other things, which also would have affected their companies in UK. Kamal, are you there? Can you come in and give your thoughts?
Yes. Thank you. I apologize for the delayed interaction. I think we are all bracing ourselves with the guidance with the ICO here in the UK. And according to the Information Commission Office, that a statement is going to be released early next week, probably sometime soon, because we are coming to nearer and nearer to the deadline, 1st of January, and the guidance of how all the data transfer should be done. But I think Mr. Rajesh has already mentioned very good points, that this can apply in different way, and but equally, it's a risk-based and proportional approach, about the oversight of international transfer in accordance with the regulatory action policy. But all the local organizations, local companies, they are very much waiting. We're all waiting, I think, for proper guidance from the ICO. And it's like a sticking point, that this has opened up a can of worms, but it's also important how the data is collected, where it is. Is it based in the EU? Now we are not going to be based in the EU anyway, because we'll probably be considered as a third country. And that is the worry. But the business at the moment is as usual. People are just waiting for guidance from ICO, and that's the concern,
Okay, I think Kamal got disconnected, I suppose. Anyway, on my personal behalf, I thank all the panel members. Of course, there's a formal vote of thanks Samyukta will handle, but my personal thanks to all of the panel members, plus the guests who I randomly called them to make comments, Vikram and Sudarshan. Thanks for all your inputs. And as far as before we wind, I give it to somebody else for a vote of thanks. I would like to mention for the participants that our next session will be tomorrow at 11 o'clock. We will be taking up another interesting Indian phenomena called data trust score. And tomorrow afternoon we have another specific vision in terms of the framework for compliance. I am sure that most of you would be interested. Please attend in large numbers. Plus, any feedback on these sessions and our attempt to have this Indian Data Protection Summit as a 6-session program to try to bring as much of information about Indian data protection requirements to the professionals as possible. How did you receive it? What is your feedback? Please send it to PPI through their our website where the email address is there, or through personally to any of us whom you so desire. Okay, back to Samyogita.
Yeah, sir. Thank you, sir, for that wonderful session, and thank you all our panelists for their discussions. Would request Dr. Mahendra Limai to give the vote of thanks. Over to you, Mr. Limai.
Yeah. I thank all the dignitaries who shared their views, starting from Mr. S.P. Arya, Meena Lal ma'am, and Mr. Rajesh Vishwanath. Due to his health, we were not able to trouble him more. We would like to hear more about streams 2 from Rajesh in another coming sessions. Also, I would like to thank the guest participants, Mr. Sudarshan Mandya, Mr. Vikram Patil, and Mr. Kamal Acharya. I need not thank our own Mr. Navi because his tiring efforts are appreciated by everyone, and we wish all the good health and success to Mr. Navi. With these words, I call upon all the participants to join tomorrow at 11 a.m. for our another interesting topic, which is innovative concept as far as data privacy is concerned. That is data trust score. It is our own local or global concept which India has developed. So join us tomorrow morning at 11 a.m. Thank you. Thank you from FDPPI.
Thank you all.
Thank you all.